Bismillahirrahmanirrahim. We are again back after a long break due to unavoidable circumstances. And in this vlog, in this sitting, we shall discuss lecture 8, part 2 of international law. And the question is about the theories regarding relationship between international law and state law. In the previous sitting, we discussed the monism or monistic school of thought regarding relations between international law and state law, and in this we shall discuss the dualism. Dualism, by the nature of its name, the dualism believe and mean that the international law and state law both are two different laws and two distinct areas. Whereas according to the monistic school of thought, the both laws are a single law or a single system or a part of single system, but according to this one, both are entirely distinct legal systems. International law having a different character from the state law. The subjects of international law are states only, and the subjects of municipal law are the individual. Furthermore, the source of state law is the will of the state itself, and on the other hand, source of international law is the common will of the state. This is the base of dualistic school of thought, which provides that both international law and state law are different law. At the early stage of development of international law, such theory was not available. Only the monism school was prevailing, but with the passage of time, the positivist school of thought or writers like Triple and Anzalotti have founded this school of thought, and they provide that the both laws are different. According to Triple, the subjects of state law are individual, while the subjects of international law are states solely and exclusively. Their juridical origins are different. The source of the state law is the will of the state itself. The source of international law is the common will of states, as we already pointed out. According to Anzalotti, the international law and the state law, according to fundamental principles by which each system is conditioned, he is of the view that state law is conditioned by the fundamental norms and state legislation is to be obeyed, while international law is conditioned by the principle Pax sunt servanda. The criticism on this school of thought is that practically we find the primary concern of international law is the right and duties of the states, but the individuals are also the subjects of international law, like other multinational companies and INGOs or UNO organs are also the subjects of international law, and this one is missing in this school of thought, this theory. One can not say the pirates, slaves and hijackers are the only subjects of international law. This is the valid criticism on this school of thought. As to question of primacy, which law is sovereign or which law is the primary law, either the international law or the state law? According to monism, monistic school of thought, the state law is the primary law or have the sovereign authority, but the monistic school of thought, dualistic school of thought is divided on this point, and the monism is at certain point has also a different point of view, but according to dualism, prima facie the international law is the primary law and the state law is the part of the international law. But according to monistic, both theories are prevailing regarding primary base, but considering the facts and the circumstances, there are two crucial cases which can be considered to answer the question. First one is, if international law drew its validative from state constitution, it would necessarily cease to be enforced once the constitution on which its authority rested disappeared. But the operation of international law is independent of change or abolition of constitutions or of revolutions. The second one, the entry of new states into international society, it is well settled principle that international law binds the new state without its consent, and such consent, if expressed, is merely declaratory of the true legal position. Furthermore, it is the duty of every state to bring not only its law but also its constitution into harmony with the international law. At the concluding regarding primacy, according to Dualism school of thought, international law is primary law and sovereign law to the state law. But monastic school of thought is divided on this point, and this issue is still debatable. But according to scheme of thought and prevailing circumstances and legal system, the primacy as to base of law is lies with international law. Thank you very much.